Buckle up, because this courtroom hearing takes confusion to a whole new level. Today, we're watching Daniel Mcoo. That's how he pronounces it, step into court once again. This time, representing himself on a felony charge of resisting and obstructing a police officer. From the moment the judge asks if he wants a public defender, things start to unravel fast. What follows is a chaotic dance of legal misunderstandings, misplaced motions, and a defendant who seems more interested in talking circles than actually defending himself. He brings up Miranda rights, asks to suppress body cam footage he hasn't even seen, and tries to pause the case until he feels ready. If you've ever wondered what happens when someone walks into a courtroom with legal buzzwords but no plan, this is it. And believe me, you're not going to want to miss what this judge does when it all spirals out of control. Keep watching, because this one has everything: sovereign citizen vibes, courtroom cringe, and one very patient judge who finally reaches her limit.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here. I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do?
This is where the train starts wobbling. The defendant confirms he wants to represent himself, even after the judge clearly lays out the charge of felony punishable by 2 years in prison and a $2,000 fine. Despite this serious context, he charges forward, asking for bond changes and discovery documents he doesn't fully understand. The judge even pauses to let him know that self-representation is no joke here, held to the same standard as a trained attorney. But instead of backing down, he fumbles through motions, admits he doesn't know the procedure, and tries to reset the court's agenda with zero legal grounding. Would you ever choose to go solo in court like this? Drop your thoughts in the comments, because this guy's legal strategy is wild.
No.
Okay. So I'm going to do this. I'm going to apprise you, if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial. I can be assisted with if I can.
If you request an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until
suppression of what evidence?
Of body cams, squad footage.
On what basis would you be?
And here it is, the first real legal argument: a motion to suppress body cam footage. His reasoning: he wasn't read his Miranda rights. But here's the kicker: Miranda only applies after custodial interrogation, not just getting arrested. The judge sees right through it. And when she denies the motion for lacking any formal discovery request, the defendant's confusion only deepens. He admits he asked the clerks who legally can't give advice for guidance. At this point, the judge hints that this is heading into disaster territory. And she's right. Watching this, you almost feel bad till you remember he chose this path. Is this a case of bravery or just blind confidence?
Till there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really.
Okay, this was your best? Then you may want to consider getting an attorney. But I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go.
This might be the most unintentionally hilarious and painful moment in the entire hearing. The defendant says, flat out, "I want to go home and have all charges lifted." The judge, stone-faced, tells him that's not how it works. It's courtroom reality crashing into fantasy. This is the clearest example of how poorly prepared he is to defend himself. He doesn't understand the roles of the court, the prosecution, or even the basic timeline of a case. At one point, he's not even sure what he wants the judge to do. If you're watching this, shaking your head, you're not alone. Imagine being the judge trying to keep this hearing on the rails. Yikes.
What do you want to do, sir?
I'm not sure what you're asking. What are my options, sir? Your Honor?
The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. All right.
What do I want to do?
Here's what I'm going to do. What are you going to do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't. You seem to want this process to work a way it doesn't.
Maybe that's the disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing. And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied. You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense.
And here's the moment it all unravels. The judge, after hearing motion after motion that makes no legal sense, finally questions whether this man even understands what he's doing and suggests a competency evaluation. And honestly, it's not hard to see why. He strings together random legal terms, corpus delicti, protected individual, ward of the state, like he's reading from a conspiracy forum. When legal words are used like seasoning, but there's no actual meal, it becomes dangerous not just for the case, but for the defendant himself. The judge is calm, measured, but firm. And the takeaway here? Representing yourself without real knowledge isn't just risky, could be devastating.
Let me at least have some turkey before I have to deal with this again. December 5th. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings you decide that you wish to be represented by counsel, cannot afford to hire counsel, then the attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right, thank you. What are we doing?
I think defendant has a pending motion.
Yes, go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, that there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make of that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state, and I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was here to do. Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant reply that he was having trouble playing it on both his laptop and on his phone. I will note, I'm just seeing today, it looks like the defendant may have a MacBook, and I know that those can have a little bit more of a difficult time with some of the audio files that come from my office, so that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of...
I believe it's the 911 call that brought the officers to the scene.
Now calling case number 25S00289. This is the State of Michigan versus Daniel Ryan Mcoo. Can you please state your name for the record?
I'm trying to figure out what the charge is.
Yes, that is the purpose of the hearing today. So, as
Who's the complaining victim?
As part of the proceedings, can I have you please state your name for the record?
My name is Daniel Mcoo,
Okay.
and I am not a surety of the state. I'm not a ward of the state.
Okay.
Can I ask what the charges are?
Yes, I am getting there. Please give me a moment. So what we are here for today is an arraignment. The purpose of an arraignment is to inform you what you are being charged with and to make sure that you understand the charges. I am not going to be asking if you agree with the charges. I am not even going to be asking if you understand why you are being charged with them. The purpose is to make sure that you understand what the charges mean and that you understand what the potential maximum penalties are. So, what I have here is a misdemeanor complaint that charges that on or about or between the dates of February 15th, 2025 and June 23rd, 2025, you did maliciously use a service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace and quiet of an individual with whom you have a child in common by using any vulgar, indecent, obscene, or offensive language, or suggesting any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. This is otherwise known as malicious use of a telecommunications service. Do you understand what the charge means?
I do not understand that. I do not understand malicious use of a telephone service.
Do you comprehend that what I am saying is that you allegedly maliciously used a telecommunications service device that would generally be a cell phone? I suppose it could also be a computer or something else.
No, that didn't happen.
Okay. And
February,
as I
what were the
stated,
dates? What dates?
between February 15th and June 23rd.
Of this
of
year?
This year. Yes. Okay. Now, as I stated at the beginning, I'm not asking you if you agree with the charges. I'm not asking you if you understand why you're being charged with them. What I want to know, basically, is do you know what the words coming out of my mouth mean?
No.
Okay. So the way that this is going to work is this. If I am not able to arraign you on the charges because I can't tell if you understand what I am saying, then the next thing that happens is that you get referred for a competency evaluation. At this point, I do not know how long that will take, and that means that you will stay where you are until we are able to either arraign you or you are determined to be incompetent.
So I don't have, I'm not, like I said before, I'm not a surety. Yeah. I'm not a ward. I'm actually a protected individual, and I did no crime. There has been no body of a crime, no corpus delicti. I have committed no crime at all.
Mr. Mcoo. If I cannot determine whether or not you can understand what you're being charged with, then I cannot arraign you.
Okay.
So,
If there is not a body of a crime, if I have not harmed anybody, then you can't arraign me. It's corpus delicti. It can't happen. And if you do try to enter in a plea of competency, or I don't know what is that? What you're gonna hold me here hostage until what? A body of a crime happens? When is the crime gonna happen?
It's actually, I'm not even mad. That's amazing.
okay. So, Mr. Mcoo, we will not be proceeding today with the arraignment. You are free to go to the door and tell the jail that you.
This hearing ended not with a verdict, but with sheer exhaustion. The court couldn't even proceed with an arraignment because the defendant couldn't or wouldn't understand the basic charge. A competency evaluation now looms, and the judge is left navigating a legal maze built entirely by the defendant's confusion. This case is a textbook example of why legal training matters. There's a reason courtrooms run on process and not passion. If you found this case as shocking and unbelievable as we did, make sure to hit that like button, share your thoughts in the comments below. And don't forget to subscribe for more jaw-dropping courtroom breakdowns every week. You won't believe what happens next in the world of real-life legal drama.